of speech that most everyone agree is the problem and should be outlawed. It's overbroad in that it sweeps within its ambit speech that is innocent, helpful, not harmless in any way, not harmful in any way. And Chief Justice Roberts pointed out that this law includes not just maiming and torturing animals, but wounding or killing them. Well, that imperils hunting videos, of which there are many, and lots of people who apparently to watch hunting videos in which animals are deliberately killed or wounded. And it would also, he pointed out, might make unlawful bullfights, videos of bullfights, rodeos, safaris, and slaughterhouses. So it was overbroad. And the government attempted to save the law by arguing that these depictions of cruelty to animals constitute a category of speech that has so little social value that it shouldn't be protected by the First Amendment at all. Look, Justices, you don't have to get into any analysis about compelling interest and narrow tailoring and worrying about the interests on one side, the interests on the other side. This is a category like obscenity that should have no protection at all. Why? Because the depictions of animal cruelty, how can you say that that is a path to finding the truth? It has no social value at all. Treat it as such, treat it as a banned category. And the government proposed a simple balancing test. Whether a category of speech enjoys protection depends on balancing its value, does the speech have societal value, against its social costs. And Chief Justice Roberts flat out rejected that approach, saying that this free-floating test for First Amendment coverage was startling and dangerous, and that the free speech guarantee of the First Amendment is not limited to categories of speech that survive an ad hoc balancing of relative social costs and benefits. Why? Because the First Amendment itself reflects a judgment by the American people that the benefits of restrictions on the government outweigh the costs of society having to deal with unpleasant materials. He said, our Constitution forecloses any attempt to revise that judgment, the judgment made by the First Amendment itself, simply on the basis that some speech is not worth it. No freewheeling authority to declare new categories of speech outside the scope of the First Amendment. Sounds like the death knell of the categorical approach to free speech cases. We don't have any authority to declare new categories of speech outside the scope of the First Amendment. He acknowledged, of course, that the court had recognized several such categories over the years: obscenity, libel, fighting words, and so on. Those still exist, but we're not going to add to them. That's great. The government also tried to save this law, the animal depiction law, the cruelty depiction law, by arguing about the exceptions clause. Well, if the speech does have social value under our exceptions clause, then we won't prosecute it. And that ensures that speech with social value will not be criminalized. Roberts, this was a really great opinion that Roberts wrote. Roberts rejected that argument, saying most of what we say to each other lacks those listed values. So that the government could outlaw them. I mean, we talk about gossip, we talk about the weather, we talk about sports, we talk about entertainment, we talk about a zillion things that simply because they don't fall within the government's definition of socially worthy speech would be imperiled if we adopted this approach. All kinds of folk wisdom might be examples. And the court nipped in the bud this legislative technique that Congress has been using of saying we restrict this kind of speech, but we won't restrict it, not prohibited, if it meets our social value test, like in the obscenity law, and like the court attempted in the animal cruelty case. Roberts concludes that the First Amendment protects against the government. It does not leave us at the mercy of noblesse oblige, that the government will refrain from prosecuting us if it thinks that your speech has some kind of government-defined social value. Well, Nick?
So, this law has been struck down. Why does the FCC make this? Why can't you?
Why does the what?
The FCC?
Yeah.
You know, like, what was their name? Did that slip on those people?
The Janet Jackson?
Why was that a controversy, considering that the Supreme Court said that?
Said that what?
Well, that you can't put these exceptions.
Yeah, well, that's a subject that we will consider in great detail, and we'll get a peek at Janet Jackson's breast. But be patient, because that involves the FCC's policing of indecency, which is a category that the government created to govern the airwaves, over-the-air broadcast, to prevent indecency being broadcast on radio and television. It's sort of a subspecies of obscenity. And the definition of indecency is very much like the obscenity definition. But it only applies to the airwaves, and we'll consider that when we get to the question of whether the First Amendment has different effects, depending on the medium of communication. So what happens now? Well, Chief Justice Roberts says maybe a more narrowly, carefully drafted statute would be able to pass constitutional muster, something that was limited to real crush videos, for example. The legislative history of the animal cruelty depiction law showed that the Congress was concerned about crush videos, and when he signed the bill into law, President Bill Clinton directed the Justice Department to prosecute only those depictions that appeal to the prurient interest, borrowing the part of the definition of obscenity, which of course the Bush Attorney General ignored and prosecuted Stevens, for example, whose dogfights don't appeal to the prurient interest. Well, Roberts said, well, maybe if you limited the law to crush videos, that would be constitutional. Well, Congress immediately sprung into action after the decision and passed a new law that President Obama signed in 2010, December 10th, 2010, that has some odd provisions. See what you think of this as a legislative technique. The overwhelming bipartisan support for this new law. The Animal Crush Video Prohibition Act that changed the nature of the prohibition a little bit, intentionally crush, burn, drown, suffocate, or impale the animal. And it must, the depiction of the video must be obscene. And it has a provision in the law that says it doesn't apply to veterinary practices, slaughterhouses, hunting or fishing videos. Well, what's the effect of a law that says if it's a crush video that shows the intentional crushing, burning, whatever, of an animal is illegal, and it must be obscene? What does that add in the way of protections for our society? What does it protect our society against, anyway? It's a useless piece of legislation. It means nothing. If the material has to be obscene, it's already illegal under all of the federal obscenity laws. It's already illegal. So having to prove that a crush video is also obscene adds nothing to the law. You could have been prosecuted for obscenity. You don't have to look to this law. So that's where we are on categorical restrictions on speech, and that's where we are on the savings clause kind of technique for the government justifying restrictions on speech. Monday, we'll do commercial speech, which traditionally, up until the 1970s, ads was considered a category of speech that didn't have any First Amendment protection at all. So you?
Yep. Didn't Roberts strike down number 3 of the Miller case?
No, he didn't. He had nothing to say about the Miller case. Obscenity was not involved in the Stevens decision as the court decided it. I predict that the court will never again have to address the question of cruelty to animals crush videos because Congress is requiring that the material be obscene means that there won't be cases. No, it doesn't work. All set? See you Tuesday.